Hey folks, Dale Davidson here. Glad you are joining us today. We've had a couple of questions over these last couple of weeks about probate. And we've got a lot of facts out there, got a lot of fiction, okay? So we're going to do fact or fiction today with probate. And so let's go ahead and start off. One of the biggest things we get is, look, I'm married and everything goes to my spouse anyway. So I don't need a will because there's nothing to probate. Well, that is a fiction. Okay, everyone needs a will unless you want the government to tell you who's going to get your property, how they're going to get your property, when they're going to get your property, and who is going to be in charge when you're not here. But probate always depends upon the title to those assets. How are those assets titled? So, continuing on with this scenario, I'm married and everything goes to my spouse. Let's play the what if game. Okay, what if you're married and everything goes to your second spouse? So you have a second marriage or third marriage, however many marriages you got, okay? But you have children from a previous marriage and you don't have a will. Everything doesn't necessarily go to your new spouse, okay? Your new spouse will get, if you're here in Georgia, it's a child share. So let's say you have 2 children and a spouse, children from a previous marriage. So your 2 children will get 2/3, and your new spouse will get 1/3. Okay? What happens if you have young children and you don't have a will? Well, then that complicates things because then you're going to have guardian ad litems appointed for the children to make sure that their rights are protected under the administration. You have, you're married, everything goes to your wife or your husband, but you have an estranged child. You don't have a will. You don't want that estranged child to receive anything, but guess what? Under the laws of intestacy, meaning you died without a will, then that estranged child will share in the estate or in your estate. You may not want that, okay? So, and then, hey, pay careful attention to this. Make sure that your beneficiary designations are up to date on your annuities, your life insurance, your 401ks, your IRAs, and things of that nature. Very, very important. Okay? Fact or fiction, I have a will and everything goes to my spouse, so I don't need to probate. So we're talking about I have a will, it goes to my spouse. Well, again, it just all depends upon how the assets are titled. I'll give you some examples. So, many years ago, before 1986 here in Georgia, husband and wife owned real estate, okay? And I have myself and my wife Rhonda as owners. I die. Well, the presumption back then was I owned my half, she owned her half. Okay? That's not how it is today. But in this case, you would have to probate my half of the house to get it to Rhonda. So again, title always matters. You always got to look at the title of your real estate, title of your bank accounts, title of your cars, boats, whatever it is, look at the title. And be careful with banks, okay? Banks have a tendency to put children on your bank accounts joint with rights of survivorship. Maybe you've got one child and that's okay. But if you've got more than one child and you have a bank account that's joint with rights of survivorship and you have only one child on there, then that child gets that account. Doesn't have to share it with the siblings, okay? Doesn't have a legal obligation to share it, but may share it nonetheless morally. But I have seen occasions where the child says, hey, Mom and Dad put me on that account, that's my account, I'm keeping it. And it creates a lot of stress and strife in families. So again, be careful as to how you title it, especially with bank accounts, CDs, savings, checking, whatever it may be, okay? May want it that way, but just make sure that you're comfortable, okay? So I have a trust, so I don't need to probate. Now, there's different types of trust, and we've discussed these in previous videos. There are revocable trust or living trust. Those are trusts that you create during your lifetime. And there are irrevocable trust that you can't change. Okay, once they're created, you can't change it. And then there's trust that you create inside of a will, a testamentary trust. Okay, the testamentary trust does not come into effect until you pass away. Okay, but the living or revocable trust is in existence today, just like the irrevocable trust. But the testamentary trust doesn't come into play until you pass away. So, for our purposes today, we're only talking about the revocable, the living trust, and the irrevocable trust. Now, it is true that assets in the trust pass outside of probate. They're not subject to the rules and regulations of probate. All right? But, again, it gets back to how are the assets titled. Prime example, I have some clients down in Florida, checked on their property down in Florida and in another state. They've had this trust since 2002. None of their real estate was in the trust. So if something had happened to them in the meantime, we would have to do an ancillary probate in one state and do the probate down in Florida. So luckily we caught that. We were able to get those deeds done, and now we've transferred the property into their trust. So again, it just depends upon title. Title is very critical as to whether or not you have to probate or not. So we talk about probate and we talk about administration. So what is probate? Probate is a legal proceeding where you have a will. And you have a will that says, this is what I have, this is who I want to get it, my stuff, this is how I want them to get my stuff, and this is who I want to be in charge. So you go to the courthouse after somebody passes away and you file a petition, and then the court appoints that individual as the executor, or it could be called personal representative, it just depends. Okay. Now, administration is different. It's more complicated because you've died without a will, okay, so that you are intestate. And so it's a little bit more complicated, but it's the same process. It's just you have to jump through some more hoops in order to get whoever is going to be appointed as your executor, personal representative, administrator in this case, okay. So again, everything depends upon the title to how is it worded, okay? So you have basically four types. You have joint tenants with rights of survivorship. My wife and I own a house together, and it says Dale and Rhonda Davidson, joint with rights of survivorship after our names. I pass away, she automatically gets the house. She passes away, I automatically get the house. No probate, okay? Tenancy by the entireties is between a husband and a wife only, okay? This is generally Florida property. It's exactly like joint tenancy with right of survivorship, except for it's husband and wife, okay? Tenants in common. Okay, Ron and I own our house, but it doesn't say joint tenants with rights of survivorship. It just says Dale Davidson and Rhonda Davidson. So that's tenants in common. I die. Rhonda has to go down and probate my will, if I've got a will. Hopefully I do. And in order for the house to be transferred into her sole name. Likewise, if she passes away, I'd have to probate her will to have the house transferred in my name. So tenants in common. And then, of course, there's sole ownership. If I own the house outright, but my will said, hey, look, I want my wife to get my house, then she'd have to probate my will. If I own the house outright and I didn't have a will, guess what's going to happen? She's going to own my house. She's going to get a third of my house, and then my 2 boys are going to get the other 2/3. So she's going to be sharing my house with the 2 boys. May not work out in your family. I don't know. But hey, if you want to make sure who's going to get your property and how they're going to get it and when they're going to get it, you need to have a will. It's got to be in writing. It's got to be executed in accordance with your particular state law. Okay? It's got to be done correctly. So my suggestion is go out and find you a good estate planning attorney to go through all of these things that I've talked about. But again, the main thing is, how do you own your property? Hey folks, thanks for tuning in today. Hope you learned something about probate, fact or fiction. Probate is not as bad as they say it is. But hey, you want to take a deeper dive into estate planning, check out this video on wills and trusts that I did a while ago, and it will help you out tremendously. And until next time, be blessed.